are available on call, who are available on email to answer your queries immediately as far as e-filing is concerned. So another step towards enhancing the access to justice.
Yeah, that is, if I can just interject and just say that this has been a very big
Designated
step. There
officers
have
who are available on call, who are
one minute,
available on email
1 minute.
to answer your queries immediately.
Sorry, I was just putting it the entire thing live on the YouTube, so that's doubling of the sound had come. So sorry about that. So as I was telling you that e-filing, I think I must admit that for the first time I tried during this pandemic, and it was a challenge, but eventually we were able to get the matters listed. And as far as video conferencing and live, not video conferencing, live streaming was something that bar has been demanding since long. So probably that I think the E committee or the Supreme Court is also looking at webcasting of the court proceedings. This is the understanding that I have received from few of my friends also. So probably in the adversity, as you have said, that we are moving in the right direction. Uh, but there are certain areas like even for short matters or admission matters, I think video conferencing is fine. But I don't know how viable it is for the final hearing matters.
Yes.
Yeah.
And I'd like to address that point in the last section where I make suggestions on what category of matters could be dealt with through video conference, and what category of matters would require some sort of physical oral submissions. So I would definitely like to touch upon that, and also share a bit from my experience in the US on how they would conduct final hearings, and how they dealt with such situations. Um, so just to complete this point on video conferencing, two other points I wanted to make. As far as the facility is concerned, just another pat on the back of our tech team at the Supreme Court. Just before the video conference, and I want to share this with our viewers or the audience. Just before the video conference, they set up what they do is they set up a group of people who have their matters listed the next day. They send you links to test whether that link is working. They work with you, and it's a lot of hand holding which they are which they do, and they are happy to do that. They are pleased to do that. So I wanted to just commend that team as well, because they help you do a mock trial. They help you with the technology aspect, and they run you through the whole process of how it is done. And even at the day of the hearing, they are available to you on call. They first log you in, make sure that you are being heard and that you can see the screen, and it is only then that they connect you with the court, just after they have tested the audio facilities and the video facilities. So the court is making all efforts to make this a successful venture for all of us, because we are all partners in this whole process. The judiciary and the bar and the bench, we are all partners in this whole process. So the success of this is not the success of just the E committee. It will be a comprehensive success for all of us, and ultimately the winner will be access to justice. So therefore, I think we are all working in the direction. I mean, there are glitches. I mean, we've seen our colleagues face some glitches. That's part of every system. But all of these are being ironed out as we speak. One last aspect on the video conference was a path-breaking order, which I was passed on April 6th, and the viewers may note that the Supreme Court used its powers under Article 142 and passed directions authorizing all courts, including lower courts, to use video conferencing technologies. So that is one order, I think, which our listeners should definitely read and go through. It was suo moto passed. It was a suo moto direction passed by the court. It was suo moto writ 5 of 2020. Order was dated April 6, 2020. So that order is an important order, and I think our audience would be well served by having a look at the order. So that's on the first aspect of use of technology, and how Supreme Court was alive and instantly in the first 2 days came up with this technology and made it functional. We compare ourselves to the West, but the West has been using this technology since the last 10, 15 years. In the US, it is not a new thing to use technology for hearings, but for us it is. So credit where it is due. In the first 2 days, we made the video conference facility, e-filing facility functional. So that's point number one. Point number two, on how the Supreme Court was very conscious and alive to the situation. That's the second aspect of my address. So the first order it passed, and again, this was again a suo motu order, 23rd March 2020. And the speed, just to demonstrate, immediately the Supreme Court recognized, and this was an order where they extended the period of limitation in all proceedings till further orders. This power was also exercised under 142, read with 141 of the Constitution. And this was declared as in binding order. And what this did was it extended the period of limitation till further order. So say, for example, if your limitation period was expiring during the period of lockdown, and as we all know, it's quite a challenge to file any petitions, complaints, appeals within during this period. So the Supreme Court, being very conscious of that, extended the period of limitation and gave us the ability that this period would be excluded from the period of limitation. So this was again a very path-breaking and forward-looking order. And what it did was it set the path and it gave guidance to the high courts and the various tribunals in India. So say, for example, the Delhi High Court, also again, in a suo motu order, followed by the Supreme Court order on 25th March 2020, extended all interim orders passed till 15th May until further orders. So this order was passed under Article 226 and 227 of the Constitution of India. And again, while balancing the rights of parties, it gave liberty to the party to whom any hardship would be caused due to such extension to approach the court. So again, a balanced order, extending interim orders where you had any interim protection till 15th March. They suo motu extended it. So Delhi High Court did that. Bombay High Court passed a similar order on 26th March. They extended their orders till June 15th, 2020. And they also gave liberties to the parties to approach the court for vacation of any interim orders in extremely urgent cases. So as an example, all high courts followed the path that was set by the Supreme Court. The National Company Law Tribunal, National Company Law Appellate Tribunal passed similar orders. As we all know, National Company Law Tribunal deals with company matters and matters under the Insolvency and Bankruptcy Code. And the Appellate Tribunal, in addition to having company jurisdiction and appellate jurisdiction under the Insolvency and Bankruptcy Code, also has appellate jurisdiction for competition matters. So they, NCLAT also passed orders extending the interim orders on 30th March 2020. So again, this was all taking a cue from the Supreme Court order. Similar thing was done by the IBBI as well under a notification dated March 29, 2020, where they extended the timelines which are provided under the Insolvency and Bankruptcy Code. As we know, people who are practicing insolvency law, that the insolvency is a time-bound law. So it issued a notification extending timelines under the Insolvency Bankruptcy Code, and also issued notifications excluding this period of lockdown for the corporate insolvency resolution process as well as the liquidation process. So again, all of this, I think, this I think was started due to the first order that was passed by the Supreme Court extending the period of limitation. So it set the path, and everybody took a cue and followed suit. So that is the second aspect where I thought the Supreme Court has been very alive to the current situation, and suo motu has taken as past orders. Now, Charu, the third bucket which I wanted to deal with was with respect to COVID-related matters, specifically with respect to pandemic. What I wanted to highlight here was the approach of the Supreme Court and the approach of the government. So the approach of the Supreme Court was very clear. They were very clear that they would not be impinging on the authority of the government in all these policy matters, but at the same time would act as a safeguard, as a check to see if the steps that are being taken by the government are being adhered to or are being implemented. So you could, if you have a look at the orders, or if you had a chance to see these hearings or be part of them, you would see even the government did not take an adversarial approach to these petitions that were filed to deal with the pandemic situation. So, say for example, there was this matter filed for protection of medical personnel, where the Supreme Court ordered that state should take necessary action against persons who would obstruct them in the performance of duties, which we all know is now followed by an ordinance where it's being made a non-bailable and a cognizable offense. So the other was where the Supreme Court ordered free testing, and another example was with respect to migrants. So the approach of the government as well was not to treat these matters as an adversarial matter, and at the same time keep the court abreast of what steps the government has been taking in this regard. So in vast majority of these PILs that were filed to address issues arising out of COVID, the government in a day's time, would file the status reports on the steps and actions that they have taken, satisfy the conscience of our court, and then seek for disposal of these PILs. So the Supreme Court also, I think, made a very fine balance here. They would not pass directions asking the government to take steps, because it was quite aware of the magnanimity of the situation, where it is conscious that the government is taking steps, to the best of its ability, but at the same time would seek status reports and the steps and actions taken by the government, assess them, review them, put it to both parties, and once both parties were satisfied, would dispose of the petitions with appropriate directions, as and when needed. So, for example, in the medical personnel matter, they passed directions. Another important order was free testing, as far as this pandemic was concerned, for people who were eligible under the Ayushman scheme, Ayushman Bharat Pradhan Mantri Jan Arogya Yojana, and economically weaker sections. So that was one interesting order. With respect to migrant workers, the Supreme Court dealt with two petitions, and assessed what facilities the government was providing to these migrant workers as far as their shelter and their basic necessities of food, water, and other things are concerned. It also passed certain directions with respect to how childcare centers should deal with this situation. So that's a very detailed order passed by this court, and viewers can have a look at that order passed as well. The other aspect which the Supreme Court touched was with respect to Indians who are stranded abroad. So the Supreme Court assessed that situation as well with the help of the government, and made sure that the government was addressing that issue. So essentially, the point here being that while Supreme Court, so Supreme Court entertained these matters. These were matters which affected the rights of our citizens. So the Supreme Court entertained these matters, listed these matters as urgent matters, heard these matters, took the assistance of the government, took the assistance of the council, and passed necessary directions as and when they found necessary. So that, Charu, is the third aspect.
Just to tell you, I mean, you explained it beautifully, but if I could just sum up for our listeners. So essentially, court is working in harmony, if I can use the term, with the government, and not taking these PIL as adversarial litigation at all. But court has rightly thrown number of petitions, like where people are asking free access to Netflix. So I think those are the types of the PILs which should be dealt with some cost also. But I think court has been lenient enough not to put any cost on those type of litigation. And there is one pertinent query which is coming again and again. I know you want to go on the next part, but there are some people who are asking about various how they can file the bail application and all, considering that they are getting their orders in the vernacular languages. So how is Supreme Court going to deal with those things? Like people, they are able to either WhatsApp or something, but their documents are in Hindi. for example, they are not able to get it translated. So how lawyers are managing that? This is a query which is coming.
Yes, so I'll address that straight away and then move to my next
Yeah.
section, because it ties in very well with sort of my next bucket, which is on the criminal justice system. But I'll address this question because um, um, uh, so say and the way to do it in my view right now would be that, look, the orders that are available in vernacular and need to be filed with the Supreme Court, and the rules prescribe that these have to be filed as official translations, translated by an official translator. So the way we do it is, you file an office translation, or you have somebody translate it, and we refer to it as an office translation. You yourself, as a lawyer, if you're from that region, could translate that, file that as an office translation, and file that along with an application from seeking exemption from filing an official translated version of that. And you probably know this better than I do, that that will
Yeah.
work. That is something I think would work, where you annex your translation of that document, and file that application seeking an exemption from filing an official translation, as well as give an undertaking in that application to file an official translated version as soon as things normalize. And of course, if you're able to access an official translator, then and I think we have to get used to that way of functioning now, accessing
Yeah,
people.
but other right. So this is what I was trying to explain to a few of the queries which had come, that we are doing it, but if the work is too voluminous, then it is getting difficult to do. And another problem that people very frequently come and ask about, ma'am, how we will do our affidavits and all. So we have been advising that we are doing it under our undertaking. We will file proper affidavit. That is also a part of the practice
Yes.
direction given by the Supreme Court.
Yes, yeah, that's an important point, and I think I should have highlighted that in the
Yeah.
first aspect, where the Supreme Court sort of was conscious. So this, again, this goes to the point that Supreme Court was aware that, look, we are in a position where we are not going to be able to attest affidavits. So what the Supreme Court said was that in your application for urgency, where you seek listing of these matters, you give an undertaking that today we are not in a position to have these affidavits attested, but please accept the affidavits signed by the clients for now, but we undertake to file attested affidavits as and when the situation normalizes. And the same leeway they have given for court fees, because we may not be able to acquire the requisite amount of court fee, or be able to pay the court fees. So these are things that the Supreme Court thought of, and gave us the ability to file these petitions without getting stuck up with technicalities. Because, as you know, an AOR is an officer of the Supreme Court, and his undertaking holds a lot of value, with our Supreme Court. So an undertaking by an AOR that, look, this is signed by my client, I am undertaking that we will file this, is enough comfort, given that an AOR like yourself is an officer of our court. So I think that comfort is there, and therefore the Supreme Court has done away with these technicalities. So now, just moving to the next bucket, which is access to criminal justice. Again, very path-breaking orders passed just, I think, a day before, or a couple of days before the lockdown, on March 23rd. I think the matter actually was taken up for the first time on 16th March. It was a suo motu writ which was taken up by the Supreme Court to deal with the decongestion of our prisons. Because as early as 16th March, the Supreme Court was conscious that, given this pandemic, our prisons could become a hotbed for spread of this pandemic. So on 16th March itself, it took sort of cognizance of this issue, called upon the states, and sought their views on how the states were dealing with situation, how their prisons were going to be managing the spread of this pandemic, and what steps they were taking. So during the course of this matter, on 23rd March, it passed a very interesting order, and in my view, it furthers the criminal justice system. So what it did was, it said that it passed directions for setting up of a high-powered committee And that committee would, comprise of the Director General Prisons, the Principal Secretary, and the Chairman of the Legal Services Committee of that particular state, to determine sort of the class of prisoners that could be, released either on parole or on interim bail. So what it did was it also gave an instance on when this high-powered committee could consider release of these prisoners. So what it said was that, if the prisoner has been convicted or is in under trial where the sentence prescribed is 7 years or less, the high-powered committee could consider releasing them on interim bail or on parole. But what it very nicely did was it left the decision to the high-powered committee. It did not take an en blanc decision of releasing these prisoners en blanc. So it left the decision to the high-powered committee to determine what category of prisoners were to be released, depending on the nature of the offense, looking at the seriousness of the offense, the number of years that that person has been sentenced to, and keeping in mind the severity of the offense, the nature, it left the decision to the high-powered committee to take that call. So basis that order, we have seen that the high-powered committee in various states has taken action, made decisions, and passed orders allowing convicts to be released on interim bail, parole. And very interestingly, very creative suggestions have come out of these high-powered committees. They have come up with concepts of furloughs, special furloughs, extended furloughs. So, it set the ball rolling. The Supreme Court set the ball rolling. It asked the high-powered committee to be creative and to see, where in genuine bona fide cases, deserving cases, they could release the convicts or under trials on bail or interim bail. And the other aspect they dealt with was with respect to suggestions they sought from the various states on how they could on how they are dealing with the spread of this pandemic, and they continue to assess that. In fact, if you look at the orders that have been passed in this suo motu writ, which is writ number 1, and if you read, there are about 4 or 5 orders, you will see they have recorded what steps various states have taken. So again, Supreme Court was very alive, very conscious to the situation. Another example was, where the Rajasthan High Court took the view that bail applications would not be matters of extreme urgency. Supreme Court immediately intervened and stayed that order. And I think rightly so, in my humble view, rightly so stayed that order, because personal liberty matters have to be treated as matters of extreme urgency.
And High Court itself had come to the Supreme Court and
Supreme Court. Yes. So that was, again, Supreme Court very promptly acting and staying that direction. Again, taking a cue from this Supreme Court order, the High Court passed a similar order permitting under trial prisoners to apply for interim bail. And in a very interesting order, now what happens is the Supreme Court passes this order and prisoners are released on interim bail and on parole, but they are released on terms and conditions to the satisfaction of the trial court. Now, the trial court, as we all know, will impose conditions of obtaining, of having a surety. And getting a surety in this scenario is a big challenge. So a lot of people who were granted bail could not actually be released on bail for their inability to have a surety be available, because getting a surety means having a surety be available, then having a lawyer identify that surety, having the trial court judge to be available and to be seated. So all these complexities arose in such orders. But again, the High Court itself, the Delhi High Court, passed a very interesting order, and this was put to the High Court that we are facing this difficulty. So it passed orders that, all these, it passed directions to the trial court that you release these prisoners on personal bonds and do away with the sureties. And again, it was very clear that this would not act as a precedent and it should be treated only for this pandemic purposes. But very interestingly, it passed an order that these people be released on personal bonds to the satisfaction of the superintendent of jail. So that was again order passed by the Delhi High Court. So this difficulty we have faced in the Supreme Court as well. While the Supreme Court has not passed any general order saying that these prisoners can be released on interim bail, but if you see these orders passed by Supreme Court granting bail to prisoners, you will see Supreme Court itself has been conscious and has passed directions in certain matters saying that these prisoners be released on a personal bond to the satisfaction of the Superintendent of Police. So while there is no general order as such, but there are orders passed by the Supreme Court as well, releasing prisoners on personal bonds. So another aspect as far as the criminal justice system is concerned, the Supreme Court has been listing bail applications. So matters that are to be listed, have to be extremely urgent, and what is extremely urgent is the subject of debate, discussion amongst lawyers, amongst litigants. But one category which is clear, it falls in an extremely urgent category, is an application for bail. So say, I'll give you certain sort of real-time examples. We, at our chambers have moved various applications for bail on behalf of convicts who have been convicted of grave offences such as under 302, but have already undergone around 9 or 10 years of their imprisonment or more. So we saw cases where they have undergone 10 years, 14 years, and in one of the most recent cases which we handled, the prisoner had undergone 18 years of imprisonment. And as you know, the remission rules of various states require the states to consider remission applications either after 10 years. So say, for example, I know Punjab has rules for remission which allow you to apply for remission after 10 years. Most states have it after 14 years. So this was one of the cases we did, and we moved an application praying to the court, seeking listing of this bail application on the ground that look, this convict has already undergone 18 years. His appeal or his petition is unlikely to be heard in the near future, and therefore on these grounds kindly consider his bail application. So the Supreme Court has been very conscious of this and has been listed and has been listing these matters, and on a case-to-case basis has been determining whether it has been a fit case for grant of bail or not. So what we have seen is that they are considering, of course, facts of each particular case, but they look at the age of the convict. So people who are above the age of 60 are sort of prone to this pandemic. So it's a cumulative. It's the combination of things they see, not just in isolation. So I know there was a petition filed where there were directions sought that everybody who's above 50 should be released, and which petition was not entertained, and it was directed that you have to assess these cases on a case-to-case basis. Some of the factors which the court has been looking into is the age. Then it has been looking the age of the petitioner. Then they look at the age of the appeal. So if the appeal is quite old, and a special leave to appeal has been granted in that matter, that's another factor which they look at. Then they also look at the number of years that a petitioner has undergone. So if you were to combine all these factors and, of course, facts which are specific to your case, then I think you could make out a very good case for release on bail. And the Supreme Court has done that in multiple matters. That again, I think touches upon how the Supreme Court has been alive to making the access to justice and enhancing the criminal justice system as well. So Charu, that was
yeah, and just to tell, just to add one or two things it is not that Supreme Court has passed two orders on bail. One, it has refused for blanket bail. It was done recently, somebody had made a petition because you have passed an order to release people on bail. Supreme Court further clarified that it is not a blanket order for bail for every person. And if the court consider crime as heinous and persons are even in the in the senior category, still they have rejected the bail, in the Michael Christian matter, which court considers to be quite serious. Yeah.
Correct. So I think, yeah, I mean, what the Supreme Court has seen, and this is basis my limited experience, that they don't see the age as an isolation.
Yeah.
It has to be combined with other factors. There was another matter where I was able to participate in, was where the petitioner was undergoing a severe health condition and was paralyzed. So the Supreme Court, in fact, it didn't grant bail, but it granted interim bail for a period of 4 months, so
Yeah.
that the petitioner, could be taken care of, because the
Right.
petitioner was, had a paralytic attack. So the point here being, they are alive, they are conscious, and are taking a lenient view as well. So I think, I mean, of course, there'll be cases where, they have not granted bail as well, but that is, an assessment which the honorable judges have to do.
Yeah.
Uh,
And again, it
th-
varies from judges to judges. Like we
yes,
have been lucky before one, not so lucky before the other.
correct. But I think, as I share with my colleagues, that we have to put our best foot forward, and try during these times.
Yeah.
Because one thing is very clear, that it is unlikely that these appeals, criminal appeals, are going to be heard in the near future. And if they are not going to be heard in the near future, then I think these would be fit cases for consideration at least. So therefore, they should be listed, and that is what the Supreme Court is doing. It is, in your applications for urgency, you have to set these grounds out. They assess these, and basis that they list these matters. And just one last aspect before I move on to the next. Even in these matters where bail have been granted, one practical challenge we have seen in one of our matters, bail was granted 3 weeks back, it's a very sorry state that that person is still not released on bail, because the challenge that they are facing is, they are not being able to get a surety. The court has not been able to convene the trial court, and the fact that, these are certain technicalities that are coming in the way. So of course, we have moved an application seeking an exemption from surety and a personal bond, but these are certain challenges which you will face. So if you are moving an application for bail, do make that request for a personal bond, so that you don't face that difficulty. The other thing I should point out, where the Supreme Court is assisting the litigants, is in another matter of ours, where the petitioner has not been released on bail despite a bail order. The Supreme Court registry has itself emailed and sent orders, which of course they are supposed to do. They have sent orders to the high courts and the trial courts, and have personally followed up to ensure that the convict is released on bail. So that effort is also being done by the Supreme Court to ensure that these are not just paper orders. So they are also assisting you with following up, because you yourself probably may not have the right contact or know where to go in the high court or the trial court, or who to write to or who to reach out to. So they assist you, in reaching out and communicating these orders so that they are implemented. So I know we are running very close to sort of our deadline, but just a couple of other things, which the Supreme Court, what kind of matters they have been dealing with. I mean, they are also very conscious of matters where, time for, let's say, there was a matter where we saw it was a landlord-tenant matter, and the eviction order required the tenant to vacate the premises within the lockdown period, and he moved an application seeking an extension of time. So these routine applications seeking extension of time to comply with your obligations are also being assessed by the Supreme Court. So say, for example, if you have an obligation during this pandemic time, and that period for complying with that obligation is expiring during this time, and you moved an application, so those kind of applications are also being considered for seeking extension of time to comply with obligations. And again, like I mentioned, the Supreme Court has heard other category of matters. They heard a matter relating to provision of 4G services in Jammu and Kashmir, and various other matters. The other aspect which the Supreme Court has been very active is in pronouncement of judgments. I think as students of law, and given that we have some time in hand, we should all keep track. There are multiple constitution bench judgments that have come out in the last 2 weeks or so. um, um, there have been judgments on the NDPS Act, on the reservations, on fixing of minimum the sale price of sugarcane, resolving that conflict between center and state. So, these are important judgments that are being pronounced during this time as well. So again, a point where the Supreme Court is quite active. Um, the other thing the Supreme Court is doing, and I wanted to just point that as a last point, is it is utilizing its time to dispose of the review and the curative petitions that are pending. So you will see that review petitions that have been filed and have been pending are being listed, and a number of these petitions are listed. And I think they've picked Tuesdays as the day for listing of these review petitions, where a number of our judges are sitting and disposing of these review petitions. And as some of us may know, review petitions are to be decided in chambers unless the court decides to hear that in open court. So it is something which I think they thought of, that this is something that we can do during this time. So again, their thinking hats are on. And they are listing these review petitions and disposing them off as well. And again, the collegium is active as well. As we've seen, resolutions have been passed for appointing chief justices of 3 states, I think. So Supreme Court is quite active, I would say, during these times. Just one last point, I think, just sort of summarizing, Charu, and this is where I think we can take some suggestions from you as well. I presented, and it does look like, that all is well. Yeah, I mean, it's all, these are all steps in good directions. But again, there is always room for improvement. There is scope for improvement. And one or two suggestions which I wanted to make on the use of technology. And I know a lot of us have written on the use of technology, the use of video conferences. A lot of us have expressed views for and against and have made suggestions. So my first suggestion would be that, look, we are getting so many suggestions. We need to be able to compile all these suggestions, and we need for the Supreme Court to form some sort of a committee, a subcommittee, which would involve members of the bar, which would involve experts in the field of technology, which would of course involve the judiciary, and form a committee which would crowdsource these ideas, compile them, because you have these ideas which are a lot of us are writing, expressing our views, but I don't know if all of these are being funneled through. So like a subcommittee which could sort of compile all these ideas and present it and make decisions. So that's number one. Have these ideas, compile them, present them, have a subcommittee look at it. And I don't know whether this is being done. It could very well be that our e-committee is already doing that. So a point on that would be dissemination on what steps the e-committee is doing, because all of us are making suggestions, but I don't know whether these are being taken care of, being addressed. So if the e-committee or whichever committee is looking into could disseminate on the steps that they're looking at or are looking to implement. So that could sort of ease the burden, relax some nerves, calm a lot of people. So that dissemination could be one thing. As far as filing is concerned, like you mentioned, a lot of people face challenges during the e-filing procedure. And my colleagues who are listening must be smiling right now, because I think they spent a good 1 week for the first filing, which they attempted. So what I was thinking was that, if like this webinar, if the Supreme Court registry itself could organize a webinar where they could run everybody through on the e-filing process. In the past, whenever they've introduced a new technology, they have held physical sessions to explain how the technology works. So maybe during this time, utilize a webinar and explain to the lawyers and the litigants. And a lot of these petitions are petitions in person. Have a webinar where you run the team through, the listener through on the e-filing procedure, because a lot of these questions come up. So you are emailing them, calling them, but instead of this, these could be addressed by way of a webinar. As far as listing is concerned, again, very debatable. a lot of discussion what constitutes listing, what constitutes an urgent matters. I tried to sort of explain in our experience what has constituted urgent matters. So maybe some more clarity, but that works both ways. I should warn, if you have a set list of matters where the Supreme Court identifies that these category of matters would be treated as urgent matters, like they do for summer vacations, they identify, then in a lighter vein, then you're stuck with that list. And you have to, if your matter falls within that list, it will get listed, otherwise it will not. So today, at least, it's a little flexible. So it cuts both ways. So my personal view is that we work with what we have and demonstrate the urgency, because as we have seen, the court is conscious, but we've got to keep trying. Last aspect I wanted to touch, and I know we are running close to our 1 hour deadline, is on the hearing. So this is what we've seen now. I mean, what to expect going forward. I mean, things are going to change. Things are going to change. The way lawyering is going to change for sure. And we have to adapt. And like I mentioned, there's always an opportunity in adversity, and we've taken that opportunity. The court has taken the opportunity. So we should continue taking that opportunity and, sort of categorize matters which will mandatorily be heard through video conferencing. So say, for example, where directions are to be passed, short category of matters, which they've set out a list, they've set out lists. They've described what are short categories. They've included transfer petitions, they've included bails, they've included eviction matters. So maybe that list could be, enhanced a little. And matters where, pleadings are not complete, as an example, directions are required, and where you don't need extensive hearing. For example, where a 15-minute video conference session would be sufficient. Those are categories of matters which should mandatorily be heard by a video conferencing now. That's my humble suggestion. As far as final hearing matters are concerned, my suggestion would be, as we do, as is the practice in the United States, is we put a limit to our oral submissions. And I know, again, it cuts both ways, but I think we need to put a limit to our oral submissions. We need to put a limit of 15 minutes to 30 minutes, depending on the matter. Of course, we can be flexible where matters require a longer period of hearing, but that could be on a case-to-case basis. But as a general thumb rule, we limit oral submissions, and now we'll have to physically decide whether we can have a physical hearing or not. So in physical hearings, we limit oral submissions, and whatever needs to be submitted by way of written submissions, where you set out your entire case. You put footnotes, you put endnotes, you put the judgments that you're citing. You embed documents that you want to rely upon, and save the time of the court for an actual physical hearing, because the way we are now looking at things, and if I had a crystal ball, these physical hearings are a thing of the past now. It seems there will be very limited physical hearings, and we'll of course miss the buzz of our corridors and the buzz of being in courtrooms, but we have to work with what we have, and we have to be grateful for what we're able to still do in these times. So like I say, we need to have that attitude of gratitude, and be grateful for what we're still able to do in these times, but work with what we have. So with that, Charu, I want to sort of ask you your thoughts, and we discussed this as being ahead of the e-learning initiative, being an AOR in the Supreme Court, and having seen the Supreme Court from close quarters. What would your suggestions be on how we could do this better?
Thanks, Akil, for asking this. So the first thing I require is, I don't know how feasible this is, but right now we are working with 2 or 3 virtual courts only. Normally we sit with 16 to 17 courts, 15 at least. So I think there is a strain on access to justice because of the number of availability of judges. So very few matters are getting listed. So there is a strain, but I think there is a mechanism which is going to be evolved, and things can be handled. One thing that I'm particularly perturbed about is in the circular in which the court said that from 24th April they will be hearing short matters, family matters, and death reference. Now, death reference, I have an issue that we should not have it via video conferencing. One, see, even as an arguing counsel, one prepares, an arguing counsel is only a face. He requires a team to prepare all these matter. And like if I'm citing 20 judgment, I'm not expected to be ready with 20. I need 2 or 3 people to help me out, giving this now, this, after this. So even as a preparation from us as a lawyers, as a counsel, I think that is one challenge that is there. And because it's a matter of life and death of somebody, so I
Yes.
think should be postponed for some point of a time, not because of technology, but basically because of the low infrastructure we are having. Had this been the normal time and people could come and assist me in my office, then probably fine, it could have been done. Apart from that, the working of subordinate courts and all, I mean, it is vitally affected. So people are not going to have any place to get justice. But I am told that in the state of UP, all subordinate courts have been made functional. I think this
Mm-hmm.
was done yesterday only. So that is one aspect, and I think they have realizing that they don't have that much internet. Looking at the demography of that place, so I think they are doing it through some mechanism evolved via SMS.
Okay.
So you get your red petition number or whatever your case number is, and then you SMS, and then you get some small link which takes quite less amount of bandwidth. So exactly, I am not able to gather what it is, but probably even for Supreme Court, we need to have something like this. And the third suggestion would be, which you already have made, that for video conferencing, you can speak only to a limited point of a time. Because I was just reading how much bandwidth is taken by when I have a 1 hour webinar. So I could not get for video app which Supreme Court is using, but for
Mm-hmm.
Zoom, if it is in the HD quality, then it takes around 2.5 GB of data, right? So that is
Huge.
huge. In a group conference, assuming it is only 5 people out there, if it is more, then it will be more. Because I don't know the stats exactly how they are distributed, 2.5 GB for who all, or it is for one person each 2.5 GB, then it is too high. And even if you go on the lowest format of the video you are delivering, then also it takes around 850 MB of data.
Mm.
So 850 MB to 2.5 GB, still it is too much for an average person, because many of us will be running on mobile data. Very few will be having fiber or LAN at their places. So I think that is one aspect that has to be taken care of. And one way to take care of it by way of written submission.
Written submission.
Written submission, and when we give them in the soft copy, it will be further easy for them to utilize that material. And as far as the listing of the matters is concerned, that has always been a gray area whether we do it in the physical form, and or whether we do it on in the online mode. So that is a gray area that will remain a gray area. You can at best do persuade, because now you can talk to them on telephone. Otherwise, we were running our clerks to the offices.
Right.
So this is one area that is being done. And finally, if somebody is listening and somebody can take it to the courts, I would request that court should do something for our registered clerks. People who have
Okay.
been working for us, I mean, we are supporting them as long as we can, and we'll continue. But I think they are the ones who have to be looked at. I think like SCBA, SCORA, and all are doing for the lawyers, but I think we owe responsibility to our clerks and our support office.
Absolutely.
So that is just few points.
Absolutely. Thank you.
Right. So I'll just take if there are one or two queries. One question is there about the data security in online communication with courts, including Supreme Court. Your take on that?
See, that is a challenge. That is a challenge. And data security, as far as, any communications, any privileged documents, any confidential documents are concerned, that is going to be a challenge. And that has been raised at various fora. And I think that's something which the courts must address as soon as they can, as soon as they can. But, as an immediate solution, and I know you have to find a larger solution now on how to address confidentiality in such proceedings. But as a suggestion, and it just comes to mind, is how you see confidentiality of certain documents when you are dealing with the Competition Commission. you could seek confidentiality of the information that you don't wish for it to be shared. So say, for example, when you're filing a particular petition, you could very well seek confidentiality to be retained for for that particular aspect of your pleading, which you don't want it to be made public. So that could be one way of doing it. As far as oral submissions are concerned, I mean, if it is something which is very confidential in nature, then it is difficult to control that at this stage. And maybe again, an application has to be made in advance. The court has to be made aware in advance that these are 3 points which we would have made as oral submissions, but given the challenge, we are making it as a written submission so that it is brought before the courts. So you have to find a solution for that in the interim, while this issue is resolved.
Right. So thank you so much, Mr. Suri, for your time, and thank you to the participants for your time and providing us with an interesting question. And before I leave, I'll just like to display my website to you, because at EBC Learning, the basic idea is to provide you with the bridge the gap between the school learning and the practice, as well as to make just education more affordable. So here right now we have made around 38 courses. I'll just share my screen, just 1 minute. I'll just take 2 or 3 minutes. I had put it initially also. So tomorrow I am doing one on the powers of governor versus speaker. And these are some of the courses which we have done. We are covering vast variety. We are covering arbitration, banking. We have got competition law, one course on that. Consumer protection, we have covered the latest consumer protection with 3 law courses on it. We have got contract law, criminal law, and on insolvency and bankruptcy code, we have as many as 7 courses. And we do cover mergers and acquisition. In insolvency and bankruptcy code, we have created something known as PATH, which takes you a journey from learning the essentials, then you learn how to file it, you know the leading cases, and then we teach you even the basic aspects of the valuation of corporate assets. Apart from that, we have recorded talks with some of the senior lawyers who practice in the IBC. But because of this lockdown, we have not been able to upload it, but they are already recorded and they will be coming up here. And then we have got various channels on our YouTube, and apart from YouTube, we are also on Facebook, so you can go and check that out. And we are always waiting for some sort of constructive feedback that we can get, and we'll always try to improvise, because we'll take education, legal education, as a continuing journey. It is a continuous learning for every one of us. So thank you all.
Thank you so much for the opportunity.
Thank you so much for your time. Okay, good day.
Thank you. Bye-bye.